My name is Scott Horton. I am with Horton Law, which is a law firm that I founded earlier this year in 2017 after more than a decade at a larger law firm. I practice labor and employment law, and obviously a big topic in that area in the state of New York all year has been the upcoming paid family leave benefits law. This is actually the second webinar I've given on this topic. The other one was 3 months ago, I think to the day in September. That was more of an overview of a lot of the basics and details of what the law provides. I'm going to hit on those quickly here at the beginning of this webinar, but if you need more detail on the basic components of New York's paid family leave law, then you can find my earlier webinar and watch that. But I'm assuming that many of you are familiar with the basics at this point and are getting close to the implementation date of January 1 and wanting to know what you need to do to be fully ready to go, or as ready as you can be on that date. So here are the other topics that we're going to spend time on today and go into more detail than I did in my earlier webinar, including several things that we didn't have all the information on at that point in time that we are now at least better able to address. The employee waivers, the ability of certain employees to opt out of participation in the paid family leave benefits program. We're going to spend a little bit of time on that. We're going to spend some time talking about the request forms. New York State, the Workers' Compensation Board, has issued its request form documents that I want to go over in some detail with you. All of those forms are available online now. I'm going to give you at the end of this presentation a link to my website where you'll get all the materials from this webinar. You'll be able to get the slides in PDF format and link right there to all the various forms that we'll be talking about if you don't already have them. More on that when we get there. Okay, so then we'll talk about the policies that you need to have in place specifically, or your paid family leave policy or other written guidance that is required of all covered employers in New York State. And then building off of that, we will wrap up the discussion talking about issues that relate to the interaction between New York's paid family leave and the federal FMLA for those of you in organizations with 50 or more employees. Of course, you may have already been dealing with the FMLA and now have to deal with this additional law and its regulatory structure at the same time. And we'll talk about how the two laws interact, how they're the same in some ways and how they're different in others. Okay, so first, I guess, important question, are you covered? Is your employer organization covered by New York's paid family leave law? If it's not, then you may not need to spend the next hour listening to this webinar, or maybe you're still in a position where you could end up covered. This is not a picture out my window, but it more or less could be right now as I sit in Orchard Park, New York, where we've had probably a couple feet of snow recently. Those of you who aren't familiar with the Buffalo area may not understand or realize that the city of Buffalo itself probably doesn't have more than a couple inches of snow at this point, but I'm just south in the snow belt where we get lake effect snow bands more often, and we've been pretty hard hit. But the bigger question is not whether there's snow outside your window, but do you work for a private organization, meaning a non-governmental organization? If so, then you're probably covered with respect to most, if not all, of your employees. If you work for a private, non-governmental organization with any employees at all, then you're probably covered and need to comply with the paid family leave law in some respects. I mean, you may or may not have eligible employees at this point, but we'll get to that. There are some nonprofits that may have some exempt employees, meaning exempt from the coverage of paid family leave, but overwhelmingly most of the employees in private businesses are covered or potentially eligible under the paid family leave law in New York, even if they're not under the FMLA. Government entities, cities, towns, villages, etc., are not by default covered, but they could opt in or negotiate with their unions where they have them to provide coverage under the program. So if you're in that situation, then this could be pertinent to you as well. So real quick, again, we're going to just run through the basics of paid family leave for those who are not quite sure, or just as a background of some of the more detailed topics I'm going to talk about. The eligibility for an employee when they work for a covered employer depends on whether they're regularly scheduled to work 20 or more hours in a week. If they are, then they become eligible after 26 consecutive work weeks of employment. So basically, somebody who regularly works 20 or more hours per week, once they've worked for your organization for 6 months, they would become eligible to take leave if they have a qualifying reason. Now, this eligibility doesn't start counting January 1st when the law takes effect. It goes backwards from that. So as of January 1st, anyone who's already been employed in that category for 26 weeks will become eligible. The folks that have worked less or that regularly work less than 20 hours per week become eligible after they've worked 175 days in a 52-week period. So if over the course of a 1 year period, 52 consecutive weeks, someone that works, whether it be 5 hours a week or 19 hours a week, once they've actually worked on 175 different days, they're eligible. Unlike the FMLA, employees don't have to be employed for a year, and there's no hours worked requirement. Under the FMLA, you have to have worked 1,250 hours in the last 12 months to be eligible to take leave. That is not a requirement here. And it doesn't matter how many employees are in proximity. Employers with just one employee may be obligated to allow their employee to take paid family leave. Employee payroll deductions are designed to account for the cost of this benefit. The benefit's an insurance benefit. You all probably already know that it's provided through your disability benefits carrier, your New York State mandatory short-term disability benefits insurance has essentially a rider or additional component to it that now includes paid family leave, or at least will provide that coverage starting January 1st. So you have had the option since the middle of this year to start taking deductions out of employees' pay. According to the percentage on the screen, this 0.126. Some employers started doing that and some did not, and some still have not, and some probably will start to do that January 1st. My understanding is that the way your insurance premiums are paid would probably dictate whether you've already made those deductions if you've been speaking with your insurance broker or carrier administrators, because you probably pay after the coverage starts. In other words, for coverage that starts January 1st, you probably pay after January 1st anyway. It may be sufficient just to make those deductions along the way in January, and you'll still have enough money to pay the premiums. The Reason I scratched out up to on this slide, I mean, that's what the rules provide, but my understanding is that all the carriers are charging the maximum premium that they can, which is probably already underfunding the insurance benefit, and this will be revisited annually. But the insurers have to provide this coverage if they want to keep the disability policies in place with you, because it's all together as one. So hopefully you're all set on that. But we'll get back to some reasons why the deductions are relevant with the waiver issue. Just again, real quickly, the qualifying purposes for leave under New York's paid family leave law are bonding with a new child. That includes birth, adoption, or placement for foster care. Then the family medical issue, the family member who has a serious health condition specifically, where here serious health condition is basically the same term borrowed from the FMLA, but note that this is only leave to care for a family member, not leave due to the employee's own serious health condition. That apparently the New York legislature felt was already covered by the New York State disability benefits law. The inconsistency there is that the benefit, the pay that an employee receives is much lower under the disability benefit law on a weekly basis on average, although they can take the leave for much longer, many more weeks. But anyway, that is the difference between the FMLA, of course. Then there's the family member military deployment. This is the qualifying exigency leave that came under the FMLA several years ago. So that's a category that was carried over to New York's paid family leave program, specifically referencing the forms of leave that are available under the FMLA. So whatever the FMLA would allow for that, the paid family leave in New York allows for, and includes issues related to active duty deployment of family members. So if you need to go to see them off, or if you need to arrange for childcare because the spouse, for example, who normally take care of the child is now on military duty, the paid family leave allows for coverage there. Maximum leave allowed, most of you know, eventually is going to get up to 12 weeks, which matches the FMLA maximum, but it's phased in. So in 2018, employees can only take 8 weeks of paid family leave, although they may, in some cases, also be able to take FMLA leave, which would then run for the 12 weeks. We'll get to some issues there about how they may or may not overlap, but this is the information for you on when those changes in maximum paid family leave allowance take place. How much is the benefit? It is, according to the chart on your screen, the maximum number of weeks times the employee's average weekly wage times the percentage, subject to a cap based on New York State's average weekly wage, where the state average weekly wage will be recalculated annually. At present, the New York State average weekly wage is $1,305.92, according to the state. So the initial maximum paid family leave benefit will be $652.96 per week. So an employee who makes $4,000, for example, in a week will only be eligible to get that $653, but an employee who makes $1,305.92 will make that amount. And then that increases up to 67%, both of the average weekly wage and of the New York State average weekly wage by 2021. Okay, so here is where we get a little bit beyond the basics and talk about what are the employer's obligations. This is probably most important for you because it's the question of what do you need to be doing in the next 2 or 3 weeks to make sure your fully compliant January 1st, or at least as compliant as you can be. So there's 4 topics here that I want to talk about, and then we'll go into more detail on a couple of them. But the first is a notice posting. This is a requirement in the law that's been talked about a few different ways. I'm not sure everybody entirely understands what it is, so I want to clarify that, or at least based on my understanding reading the law. This original notice posting means you have to put something up the same place you normally conspicuously post employee rights notices, but it's not the posting that looks like what's on your screen here, for example, that says these are your rights under New York's paid family leave law, or at least it's not necessarily that. This is a notice of compliance that says that you have in place the necessary insurance. This is a form that you would currently have up for your disability benefits and workers' comp coverages. It's a DBL 120 form that you would have right now. There will be a PFL 120 form that you receive from your insurance carrier. So I want to ask the question just to the group, because I'm curious how many of you have actually received that form to your knowledge. So I'm going to put that post up here and give you a second. So whether your insurance carrier has sent that to you. Well, we may again be basically unanimous. We have a split between people saying no, they haven't received it, and they don't know whether they've received it. And I think based on the results of the yes or no vote, those of you who don't know may reasonably conclude that it's probably you don't know because you haven't received it. So we'll stop there. Nobody is saying yes, and that doesn't surprise me. I haven't heard of any insurers issuing those yet, but they should be doing that hopefully in time for you to post it by January 1st, because it's not something you can just go online and download from somewhere. All right, what you can go online is download, and you'll have access to at the link I'll give you later on, is this statement of rights for paid family leave. That's listed at the bottom of my list here, but I just want to address it by comparison because I suspect people will think this is the notice posting or a notice posting. My understanding at this point is that you are not obligated to post this. Rather, this is a document you must give to an employee who requests leave or gives information sufficient to qualify as letting you know that they may need leave under the paid family leave law. So this is sort of your notice of rights that you may be used to under the FMLA. It's actually a fillable PDF available from the state that you have to put in the name of your insurance carrier down at the bottom. But you give them this, presumably along with the relevant forms that they need to fill out to request the leave, which we'll talk about more. It's really the insurance carrier's obligation to process the forms once you give it to the employee, although you have a role in it as the employer, but you do have to provide this statement of rights along with the form, or maybe even before or separate from the forms, again, once the employee has put you on sufficient notice that they may want or may qualify for paid family leave. Your other requirements are things we're going to talk about in more detail. The written guidance. This means that you basically have to have a paid family leave policy in place. All employers who are covered, even if you only have one employee, you either have to put it in your employee handbook or manual if you have one, or if you don't have one, you have to distribute otherwise to all employees some form of written guidance on the paid family leave law. We'll talk about that. And then the waiver issue is one that we'll talk about as well, but the reason it's an obligation is because the regulation to the paid family leave law make it pretty clear that the state expects employers to proactively identify employees who may be eligible to waive their leave based on their regular schedule or how long they're expected to work, what have you, and then give a form that the state has prepared to the employee where it's entirely their option whether they want to waive the, really, as we'll talk about, waive the deduction from their pay. And we'll get to that in just a minute. So when can an employee waive, and here I put coverage / contribution, but question whether they're really waiving coverage, as we'll get to, but the option to waive, and hence when the employer must notify employees that they might have the option of waiving, is one of two scenarios. Scenario where you have an employee who's regularly scheduled to work 20 plus hours per week, but will not work for 26 consecutive weeks. So someone who works full time, for example, but only on a seasonal basis or a project basis that isn't expected to last 26 weeks. Or someone whose schedule is less than 20 hours per week and they won't work 175 days in a 52 consecutive week period. So you could have part-time employees, but remember that 175 days that is relevant, and even if they only work 4-hour days, if they do that 175 times in 52 weeks, then they qualify for leave and hence can't waive coverage. Here's the actual waiver form. How well you can read it depends probably on how large your monitor is that you're looking at this from, but again, you'll be able to access this from the link I'm going to give everyone. So you can look at it if you haven't already, but some of the highlights, it's clearly optional and it says so right in the form. The employees have to decide whether they want to waive this or not. Honestly, though, I'm not sure why they wouldn't if they're eligible, which I'll get to, as I said. It also describes revocation in the document. The revocation, in other words, the employee can voluntarily revoke their waiver at any point in time, or their opt-out, as the form calls it, at any point in time. But there's also an automatic waiver. If at any point in time it now appears that based on their schedule they will become eligible based on the 20 plus or under 20 hours per week and the 26 weeks and 52 or 175 days and 52 weeks standards, then there's an automatic revocation that the rules say has to occur within 8 weeks of them becoming potentially eligible. It's not once they've hit the eligibility, it's once circumstances change that there's now an expectation that eventually they will become eligible. So that sounds like a fun administrative nightmare to me, but in other words, if you hire somebody intending it to be temporary, as soon as you know it's not going to be temporary, especially if they now work over 20 hours in a regular week, then you apparently have the obligation within 8 weeks from the time that that anticipated change in schedule is known to revoke their opt-out and start making deductions from their pay. This form also explains that retroactive deductions can and presumably should occur once the status changes, either because the employee voluntarily revokes their waiver or by automatic conditions because of their change in circumstances. The waiver is revoked. What this means is that once an employee now can't waive any longer or chooses not to waive any longer, the employer is now supposed to go back and make deductions to account for the full period of time that the employee wasn't making or wasn't suffering deductions from their pay. There's no details on how far back you can or can't go, and whether you can do it all at once or you have to do it over time. What happens if the lump sum deduction will put the employee under the minimum wage? None of that's addressed, and we'll have to see how those issues arise probably. But the form does something to tell the employees about that, although perhaps not as clearly as you would like. One further complication and some ambiguity in the form and the regulations is that the language on the form, which matches language in the regulations, says, I understand if this waiver is revoked, my employer may take retroactive deductions for the period of time I was covered by this waiver, which is what I just said. And in the same sentence, and this period of time counts towards my eligibility for paid family leave. It is not clear to me what that means, but I don't think it means that the employee now loses their 8 weeks to start and eventually 12 weeks. I don't know whether maybe they do lose it if during that time they were actually on leave and it would have qualified for paid family leave, etc. But I think what it means, or what the regulations and the law overall probably will be interpreted to mean, is that if an employee has elected the option to revoke the or opt out of the deduction from their pay and then becomes eligible for and takes paid family leave, then they can automatically start taking paid family leave immediately, assuming they've become eligible. Put all that together, and what I'm saying is I really don't see any reason why an employee who's eligible to opt out wouldn't just opt out, not suffer the deductions from their wages unless and until they have to, and they're not going to actually lose the ability to take any leave because either they're not ever eligible for it in the first place, or if they do happen to become eligible, then there's going to be nothing stopping them from taking it anyway. So I don't think they're actually opting out of coverage of the right and benefits that the law might afford them. They're just opting out of having deductions taken until such time that they either become eligible or are on the track to potential eligibility for leave. I don't know that you have to tell employees that there's no reason for them not to opt out, etc. But I think if you put everything together, that is the scenario that we're pretty much going to be facing. Not to say that there aren't some employees who would just be willing to have the money taken out in the first place, even if they don't have to. It's not a tremendous amount of money, especially if you make relatively high wages or salary, and it may not really motivate people that much to opt out, but I don't see much downside to the individual employee in doing so. But I also don't know how your insurance carrier is going to handle that exactly, adjusting premiums, etc., and whether they're going to scrutinize that automatic revocation of the deductions, etc. So I think we'll have more to learn on that issue. All right, I think that waiver topic's pretty important because I think a lot of you are going to have an administrative hassle dealing with that, the way the regulations address it. This next topic may not be quite as much of a hassle for most of you in organizations where you have employees that are requesting leave. If you're already dealing with FMLA leave, then this process in itself is not going to be much harder for you to process. Might be easier because you're not ultimately making the decision under the paid family leave law. The insurance carrier or an administrator is. But if you're already used to dealing with FMLA, that means you may also be in the boat of having to deal with simultaneous FMLA and paid family leave eligibility issues, which could be something of a nightmare. But I do want to go over the request forms to some extent because they are now out and available. So here's the request procedure as it's spelled out. The employee is going to say something, right, that they need to take time off because of XYZ. They may or may not flat out say, I need paid family leave, but they're going to put the employer first on sufficient notice that they need this. Theoretically, they could go directly to the insurance carrier or just get the forms through whatever mechanism is set up for them to get them, and they could even go online and get forms, which we'll talk about. But so the employee is expected to complete part of the form, then give it to the employer, who then completes additional information and returns it to the employee. It's then the employee's duty to add any necessary certification information and then submit it to the insurance carrier or administrator, perhaps. At which point in time, the carrier has to review it and either deny or pay the benefits within 18 days. Now, sounds pretty straightforward, but I don't know whether it will be in all cases. Hopefully it will be, at least in some cases. The first form, the one that the employee initially fills out in part and then provides to the employer to put some additional information, is a standard request for paid family leave form. Here are the first 2 pages of it on your screen. Really coincidental that the forms use the exact same or virtually identical color scheme to my slide template. So that was not intentional. They came up with their own colors, and I've been using this template for months now. So it does match kind of nicely. But these are the actual forms that the state has put out. Note real quick that while the regulations from the Workers' Compensation Board make it pretty clear that the insurance carrier has to accept the state's forms, the insurance carriers may come up with their own forms, including telephone filing methods and stuff like that. But even if your carrier comes up with its own forms, it has to accept these forms. And that's what I was alluding to earlier. Hypothetically, an employee could just go straight to the state's website and get the forms and show up at your door and say, here, I need you to process this. That probably won't be what happens in most cases. They'll probably get the forms from you, in which case you may provide these forms, or you may be providing forms that your insurance carrier has given you to use. You might even be sending them online somewhere to access the forms. But if you do get these forms, you can't just say, no, this isn't acceptable. I need you to fill out these other forms. So the way this is set up, the beginning part A, which is shown in front of you, is completed by the employee. It starts with a lot of basic demographic information, name and social security number, telephone, that type of thing. There's even a question for race, which it says is optional for research purposes. And then they identify what the basis for their request is. And then they, put information about how long they've been working. That's going to help the carrier determine eligibility. Then Part B is to be completed by the employer, where again you confirm a lot of the information that the employee has provided, including about the length of their employment. You also have to put wage data in there that will be used to calculate their benefit amount. So you have to list their last 8 weeks of gross wages, which is what is used to determine the average weekly wage. You also provide information about the number of days and weeks that the employee has already taken off for disability and or paid family leave in the past 52 weeks, if applicable. And you have to, in this form, give the employee the information about the insurance carrier so that they can then submit the form to the carrier to request the leave. That form is uniform for any of the qualifying circumstances, and then there are separate forms that go with the 3 different categories of circumstances for which employees may take paid family leave. So in the new child situation, there is a bonding certification that the employee would have to provide to the insurance carrier. This form doesn't get submitted to the employer, or at least there's nothing to provide for or require that. Rather, once they get the completed form back from the employee, the standard request form, they then fill out this bonding certification form that I'm putting up on the screen here, and it's relatively short. It's really 1 page and then a sign off on the second page saying that everything here is true, but it needs to identify the child's date of birth and gender and whether the employee lives with the child. Interesting, I just looking at the form on gender, it actually has 3 options: male, female, and not designated / other. So, that's something you wouldn't have seen on this form not too long ago. But just for what it's worth, that is on there. They ask whether the child is the biological child, a stepchild, a foster child, an adopted child, a legal ward, or a spouse or domestic partner child. So clearly this form of leave is available pretty broadly in a lot of different situations. And then there are a bunch of different forms of documentation that the employee can use. Almost all of them are just a copy. So for example, a copy of a birth certificate, for example, to corroborate the request. If it's a foster care or adoption situation, there'll be some form of legal paperwork that would need to document that. So that one is pretty straightforward in most cases. The medical forms are probably the most complicated, although the forms themselves are really not that involved, probably not as involved as they should be in some situations. So again, I'll put the forms up. This is the first part of the documentation supporting a request for leave for a family member's serious health condition. This is really an authorization form that is signed by or on behalf of the family member who has the serious health condition, which in some cases, of course, could be the employee, him or herself, as a parent of the child with the serious health condition. But if it's an other family member, they may need to sign the authorization. Then the authorization would be used in addition to this form to give to the medical provider to then fill this form out and give information back to the employee and the insurance carrier to enable them to decide whether or not there's a serious health condition or what the timing of it is, etc. The authorization does not authorize the medical provider to release the information to the employer. And I suppose there's at least an open question whether an insurance carrier who gets medical information, including what's filled out in this form, may then discuss that with the employer. I frankly think the law and regulations intend that in some cases they would be able to have some discussion. But A, I'm not sure of that. And B, I'm not sure that this form makes it clear that that would be okay. So again, we'll have to see how that goes. But of course, it is the carrier's obligation to make the leave designation and determination anyway. If you're simultaneously dealing with the FMLA, however, you'll have separate medical certifications in some cases that you will be looking at. So there may be two sets of paperwork that need to be prepared by the doctors and returned to different parties. So that could lead to complications, but we're just focused on what the paid family leave process is for now. One interesting thing about this is first of all, I'm not sure that there's a lot of detail from the doctor here, and maybe not sufficient detail. It just is somewhat cursory and there's not a whole lot of space. I'm sure the instructions suggest the doctor could attach additional pages, but in my experience, I wouldn't count on too many of them doing that. They're likely gonna just try to check boxes and write down the minimum. So there's one line for diagnosis. There's some boxes for how often does the person require care. And then there's, boxes for the healthcare provider to give their personal information. Are they a doctor? Are they a dentist, etc.? What's their contact information and so forth. And then they sign off on it. So whether this really collects enough information to make the decisions that need to be made will remain to be seen. Finally, the military leave form. This form, again, gets the employee's information and then basically just includes as a attachment whatever form of documentation supports the military qualifying basis for the leave. So there's a lot of variation in what could qualify. So it's pretty open-ended, but there are some suggested examples of what might be sufficient in various situations. So, like I said, the first 2 pages are really succinct and just envision that someone's going to attach documentation. This last page is just an optional form to be used in some cases if there's not other documentation for somebody to describe the nature of a meeting that had to take place or an event or something like that for which the person needs to take off work because of their family member's military deployment. One question that did just come up, what constitutes a family member, same as FMLA or different definition? We are going to get to that in just a minute. Paid family leave policies. Again, as I mentioned, you all have to have some written guidance in place. If you have a handbook or manual, it has to be in there starting January 1st. If you don't have one, then you have to otherwise put it in writing and distribute it to employees. I want to quickly do another poll and see who has a policy in place. So if you'll take a second and click whether you have a policy in place or if you're almost there. Okay, so it looks like so far nobody has the policy in place. Oh, somebody has the policy in place. All right, so maybe 1 or 2 of you have the policy in place. Most of you don't, but you're working on it. And I'm sure that's a lot of what you were looking to get out of this webinar. Okay, so let's get into that a little bit. Just an overview. Again, like I said, you have to have something in writing, either in a handbook or if you don't have a handbook, distributed otherwise. For those of you who have 50 or more employees, I recommend that you have separate policies for paid family leave and family medical leave. In other words, the federal law and the state law. They may be right after each other in your employee handbook, for example. But if you try to mix the 2 policies together, then you're probably going to be facing a nightmare situation. You may have other leave policies. Again, they might be in the same section, but I would at least give them a different heading and just cross-reference each other rather than try to mix it all together, because just everyone is going to get confused. There are some required elements, or more or less required elements, but there are some optional elements that are going to depend on your particular organization and what your policy choices are. So, I can't address everybody's situation, and you may need to deviate from some of my suggestions, but what I am going to do is give you some elements that I think should be in the policy. And again, for those of you who are on this live webinar, you're going to get access to my actual sample policy that you can review, and it shows how I've addressed all of these topics. But just quickly then, the elements I suggest are a reference to New York law, something that explains that this is based on New York law and that you're going to do your best to comply with New York law, especially because we don't know how courts are going to interpret this, whether there's going to need to be changes to the regulations because the initial ones prove unworkable or what have you. So I suggest some addressing of that. Employee eligibility, you're going to want to explain the 20 or more hours in a week distinction and how that applies, and whether that, so people know whether they're eligible or not. You're going to, identify the qualifying reasons for leave, the bonding for a child, the family member, serious health condition, or the military leave. You're going to describe to some extent the benefits that they receive, primarily the amount of leave and the amount of money. I suggest you address the impact on other leave benefits. In other words, do they, can they, should they use their PTO, for example, when they're on paid family leave, and we'll talk about that in a minute. Health insurance continuation, need to explain their rights and responsibilities there. Like for the FMLA, you have to continue their health insurance, but they can be made to pay their portion of the premiums. Request procedures, you should at least let them know who they have to go to start the process of seeking leave. You should address waivers, noting that some people have the right to waive or opt out of the deduction for paid family leave. Where you are also subject to the FMLA, while I said I think you should have separate policies, I would and suggest including some language to explain, for example, that where eligible, both FMLA and paid family leave will run simultaneously. In some cases, you can't do that, and we'll talk about that in just a minute. You should also be including contact information about your carrier, for example, people to contact within the organization. And then based on some guidance from New York State, which has put out some model language for employer policies, there should be some language prohibiting retaliation against anyone for taking leave. And I recommend using language that the state has proposed that employers use that explains how employees can file complaints if they feel they have been retaliated against. We don't know quite yet what the state is going to find acceptable by way of policies, but I think if you include that last piece, you will endear yourselves to the state if they should ever have any reason to question your policy otherwise. Okay, stacking leaves. Sorry for the pun by this image here, but this is a transition into the differences between paid family leave and the FMLA, because there are scenarios where they won't line up, and that may mean that employees separately have the right to take leave under the FMLA and then more leave under the paid family leave, or vice versa. Never mind the interaction with disability benefits and workers' compensation and other policies, but we'll focus on the statutory and regulatory paid family leave and family medical leave for the most part here. So here's a question somebody had: covered family members much broader under paid family leave. While the Family Medical Leave Act was limited to leave to care for children, parents, and spouse, the child under FMLA, or the language is actually son or daughter. It doesn't suggest the possibility of some third category like the state does, but they had to be under 18 or incapable of self-care, which is a higher burden than just having a serious health condition. So for the most part, well, by default, you could only take leave to care for a minor child under the FMLA. Under the paid family leave, it could be for a child of any age. It can be for a parent or a spouse, as well as step-parents and parents-in-law. The step-parent may be covered under the FMLA in some cases. The parent-in-law in most cases would not be. The paid family leave also covers grandparents and grandchildren, which are not covered by the FMLA unless a grandparent happened to have basically raised the employee, in which case they'd qualify as a parent in some cases. But grandparent is defined as the parent of a parent, and because parent is defined to include step-parents and in-laws, the definition of grandparent theoretically includes the in-laws of an employee's in-laws. Now, what are the odds that you'd have an employee caring for such a person? I don't know, but that's how broad that goes. Again, grandchild protection and then domestic partner protection, while the FMLA is limited to spouses. The paid family leave expressly extends beyond married couples. Obviously, in New York, including same-sex married couples, but domestic partners as well, whether they be of same or different sexes. The use of paid time off is an important difference. Under the FMLA, you can, in many cases, require employees to use paid time off, whether you call it vacation or sick time or what have you, during their FMLA leave, because you don't want them to be able to have that left over when they come back from FMLA. Under the paid family leave, both the employer and the employee have to essentially agree to allow these other forms of employer allowed leave during paid family leave. So you can allow employees to use it, but you can't require them to use it. You can allow them to use it, and then if they use it to supplement their wages or to supplement their benefits or replace their paid family leave benefits, then you could be reimbursed for the portion that would have been covered by the paid family leave benefits, the same way you can now in many cases with disability benefits. Under the paid family leave law, it only provides for full day increments, where the FMLA allows, especially for example, intermittent leave to be taken in units as small as an hour or even smaller. Actually, the largest minimum size FMLA unit you can have is an hour, but if you allow other forms of leave in shorter increments, 15 or 30-minute leaves, for example, for PTO or whatnot, then you would have to allow that for the FMLA as well. The regulations to the paid family leave seem to put a little bit of a wrinkle on this, and it says if you have employees who take smaller than 1 day increments under the FMLA, then you can add them up and then count it against their paid family leave in single day increments. So if someone it normally works 8-hour days and takes 1 hour off of intermittent leave under the FMLA for 8 days, then that could be counted against 1 day of their paid family leave eligibility. It's not entirely clear, but I think that means that they lose the right to get paid for paid family leave for 1 day without actually getting paid for it, but maybe that'll be applied differently, and maybe they would then eventually get paid. Although in many cases, you may already be paying the employee for that hour anyway. Reinstatement rights, this is pretty much the same, but there is different wording. Under the FMLA, it has said that you have to reinstate the employee after their leave to the same job or an equivalent job, where equivalent job is defined as on the screen. Under the paid family leave, it says the same job or a comparable position with comparable employment benefits, pay, and other terms and conditions of employment. So I don't know if equivalent or virtually identical under the FMLA is going to end up meaning something different than comparable, but whoever wrote comparable had obviously read the FMLA rules and knew that it said equivalent. So whether we ever find out that that was intentionally differentiated, I don't know at this point. All right, then just a couple more key differences to highlight. Intermittent leave under the FMLA has always been available for serious health conditions of the employee or their family members, but usually based on a medical necessity standard. There's really little guidance under the paid family leave at this point on when intermittent leave can and can't be taken. It's basically implied that employees can take intermittent leave whenever they qualify, whatever that means. In other words, whenever they have to care for a family member or whenever they choose to bond with a family member within their first year of birth. The FMLA does not require employers to allow intermittent leave for bonding, but they may choose to do so. It's pretty clear at this point that under the paid family leave, employees have the right to intermittent leave to bond with a new child. So does that mean that someone could take one day off a week for basically the entire year under paid family leave? As far as I know, there's nothing preventing it in the statute or regulations. Under the FMLA, you could choose your leave year. You could have a calendar year. You could have a rolling forward or rolling backward or fiscal year basis for calculating FMLA leaves. Most people used a rolling back from any date that leave is taken to calculate the amount of leave available. Under paid family leave, it's uniform rolling backwards. So how much leave have they taken in the past 12 months from today? If they've used up all of their allotment, then they can't take it until the anniversary of that first day in the last 52 weeks that they had used leave. So you could have some inconsistency there if you don't have a rolling back FMLA leave. Finally, there's no allowance for under the paid family leave law for key employees like there is under the FMLA. In 12 years of dealing with a lot of FMLA situations, I've never really had employers try to rely on their key employee exception to keep them from having to reinstate an employee. Turns out that people that are key employees are ones that you usually want back anyway, but there's no key employee exception to the reinstatement requirements under the paid family leave law. All right, well, that is everything that I wanted to get out there. So we're right at an hour on that. I'm going to take time to answer some questions. So there's a question: when we hire home health aides, we have no idea how many hours per week they will actually work or for how long the consumer will keep them. Should we have all of them sign waivers? Well, you can't require them to sign the waivers, but whether you should offer them the opportunity to sign the waiver, I really don't see much downside legally to asking or offering them the waiver. I mean, you protect yourself that way in case they were eligible and you should have given them the chance to waive it. I don't know how your insurance company is going to like it, because they're then not going to be able to charge for those people, basically. But yeah, the other thing is, once they then have worked to a level where you know that they would be eligible, you can go back and make the retroactive deductions, I suppose. So you may want to clarify that to the employees that, you can sign this, it's fully your choice, but as it says right here on this form issued by the state, you have the possibility of becoming eligible, in which case it will automatically be revoked and we will make retroactive deductions. So if you don't want to risk having all this money taken at once, you might be better off losing the, whatever it is, pennies a payroll period, or $1 or so a payroll period now. Yeah, tracking is going to be very difficult. There's rules for how you're supposed to determine their average number of hours worked, look back periods and whatnot, but nobody has bothered to define regularly scheduled. So how you know whether somebody is regularly scheduled to work 20 or more hours, if some weeks they're regularly scheduled to work 10 hours, other weeks they happen to work 40 hours, etc. Not really been clarified. So from the waiver standpoint, again, you may be better off giving it to people, explaining the possibility of retroactive deductions, and the possibility that they may quickly be considered eligible or on the path towards eligibility. But yeah, I think the waiver is an unnecessary nightmare. I don't know why they put that in. It's so little money to give anybody the eligibility to not get the deduction without apparently the risk of not being able to take the leave. Because again, it seems to me that once you then become eligible for leave, you can just take it. And at that point, you're not going to complain about the retroactive deduction because your benefit's going to be higher than whatever you're going to pay out. The question, is it calendar days or business days for the carrier's response? Let me double check that so I don't say it wrong. So I can move to another question while I'm looking for the answer to that one. Again, family member, definitely different, but I should note that under the paid family leave law, all of those family members that I showed on the slide, that was limited to the serious health condition form of leave. You can't take bonding leave to bond with a grandchild unless you are actually acting as a parent to the child. And you also can't take the military form of leave for grandparents and grandchildren. That is limited to children, parents, and spouses. What is the best way to notify current staff of the paid family leave law? Well, you're going to have to put it in the employee handbook or otherwise distribute information to them. My recommendation is, and I know some of the insurance administrators and carriers have been offering to do it, is that you actually have a meeting and explain to them how the new law works. That's not going to be practical for everybody because of the number of people involved, and you may have to make it optional to some extent. I suppose you could go to the trouble of writing a memo or even shooting a quick video explaining it and send it around to everyone. But it's tricky to write a memo that goes further than your policy, because what happens if you say something wrong or inconsistent? So even if you put it in your employee handbook, do you send the policy itself by everybody, letting them know this law takes effect January 1st? Some people you're going to have to go to as soon as you're making deductions. If you're already making deductions, you should have already been giving people the option to opt out or waive the deductions. But those are some of the considerations there. The question, where paid family leave and FMLA overlap, can you require use of PTO? The answer is most likely no. FMLA would allow it, like I said, except the FMLA doesn't allow you to require an employee to use a paid form of leave or to use more than one paid form of leave at the same time, or better way of saying it, you can't require an employee to use an optional paid form of leave when they're already on another paid form of leave. So because the paid family leave is obviously a paid leave, the FMLA would not allow you, when they're on paid family leave, to also require them to use PTO. Again, paid family leave doesn't allow it as a required matter, but I think even though the paid family leave doesn't allow you to require it, it does kind of allow you to do whatever you can do in that regard under the FMLA. The problem is, once you're on paid family leave, if you were to try to do it and require it, you'd be violating the FMLA. All that being said, employees can do it while they're on both the paid family leave and FMLA. The FMLA doesn't prohibit employees from voluntarily doing it. So when they're on paid family leave, whether or not they're also on FMLA, they have the option of using PTO. If you give them that option, you could decide that they're not able to take it, probably, but most employers don't want to do that. You'd rather them take it. Employee who delivered a baby in June 2017 and took 12 weeks of FMLA for the birth, is she eligible for 8 weeks of paid family leave in 2018? I think the answer to that is yes. The fact that someone before January 1st already took FMLA to care for a new baby doesn't eliminate their eligibility to take paid family leave. So, and the regulations are clear that you can take the paid family leave within 12 months of the birth, even if the 12 months began before June, or in other words, even if the baby was born or placed for adoption or foster care before January 1st, 2018. So yeah, they may get 20 weeks in that situation if they want it. And I know I have that one logistical question that I still need to answer. You know, the references just say 18 days on how long the carrier has to respond. So I think it is 18 calendar days, which if you think about it, it's basically 2 weeks, even depending on how the weekends fall. Otherwise, if you have any questions, here's my contact information. You can reach out and follow up. Also, if you have any ideas for webinars you'd like me to do in 2018, let me know. I'm starting to schedule some of those now, or at least plan out some of the topics that I may be speaking about. I try to do this about once a month or once every other month at least. So I welcome any comments by email or phone call or what have you. All right, hopefully I answered all the questions. I think I touched on all the ones that I saw. I appreciate all of you who stuck through a few extra minutes here, and I hope you all have a nice day, a nice week, a nice rest of the year, and you don't lose too much sleep over paid family leave before it gets here on New Year's Day. With that, thanks again. Hope to see some of you or talk to you soon. Goodbye.